Supreme Court has just released a major decision concerning one of the most defining cases brought before the justices this term. The court has just handed down a decision on affirmative action. Students for Fair Admissions, a nonprofit organization, had sued the University of North Carolina and Harvard. And the question at issue here, can public and private colleges and universities continue to use race as one factor among many in deciding who gets admitted?
Jake, what do you think about this ruling?
Okay. Brace for impact. I agree with it.
So the Supreme Court ended affirmative action. Let's talk about it. So this video is going to explain the history of affirmative action, the law behind it, and some interesting solutions that have already been put into place in states like California and Texas. So what is affirmative action? Well, affirmative action is defined as the practice or policy of favoring individuals belonging to groups regarded as disadvantaged or subject to discrimination. Now, the history of affirmative action in the United States starts with another famous Supreme Court case, Plessy v. Ferguson from 1896. Now, in that case, the United States Supreme Court ruled that racial segregation laws did not violate the U.S. Constitution's 14th Amendment, which guaranteed equal protection under the law. Now, the racist Supreme Court at that time put a great deal of weight behind the word equal. See, the catch was, as long as state facilities such as schools were equal in both quality and doctrine, then the races could be separated legally under the U.S. Constitution. Now, make no bones about it, this was state-sanctioned discrimination based solely on race, and this came to be known as the separate but equal doctrine. Now, let's fast forward 58 years later to 1954, to the landmark Supreme Court case Brown versus Board of Education. It was shown that separate but equal was a sham. It was always a sham. The mandate set forth by the Supreme Court in the past that accommodations had to be equal, quality had to be equal, and doctrine had to be equal was a farce. Here's an example. In 1946, Herman Sweat, a black man, applied for admission to the University of Texas Law School. Now, Texas was a separate but equal state, and state law denied admission to black citizens to the University of Texas. Now, Sweat's application was automatically denied solely on the basis of his skin color. He was black. Now, Sweat sued because there were no other black law schools equivalent to the University of Texas Law School in the state of Texas. Matter of fact, the Supreme Court said there weren't any law schools for black students. So the Supreme Court found that this denial of his admission because he was black violated the 14th Amendment to the Constitution. And the Supreme Court stated this: in states where public, graduate, and professional schools existed for white students, but not for black students must be admitted to the all-white institutions, and that the Equal Protection Clause required Sweat's admission to the University of Texas Law School. So what did Texas do? Well, Texas then created a new law school called the Law School for Negroes. It was a law school just for black students. But this law school wasn't equal to the University of Texas Law School because it had no independent faculty. It had no library. It didn't even have a librarian, and it wasn't accredited. Now compare that to the University of Texas's law school. They had state-of-the-art facilities, well-respected faculty, and one of the best libraries in the country. This was separate, but not equal. So the Supreme Court unanimously found that the Law School for Negroes was not equal and demanded Sweat be admitted to the University of Texas Law School. This led to the court striking down the separate but equal doctrine and making racial discrimination illegal when it came to state schools. But now this created a totally new problem. Think about this. For over 170 years, black and minority students couldn't get into professional schools. They couldn't become doctors and lawyers if you lived in one of these separate but equal states, because they didn't have law schools and med schools for black people. So if you lived in the South, you either had to move or you were out of luck. So colleges wanted to right the wrongs of the past. So they started admitting black students with things like racial quotas and holding a minimum number of seats for black students only. Now, this was to give black students an opportunity to attend these institutions since they were placed at a disadvantage with inferior schools and discrimination in the past, like what had occurred at the Texas University Law School. So affirmative action was put into place. Now, this allowed states to use race not to exclude black students, but to include them in the admissions process. So the court allowed race to be used as an element, meaning it was an essential requirement to admissions. So now let's fast forward 23 years after Brown versus Board of Education was decided to the year 1977. The case is Regents of the University of California v. Bakke. Now, Bakke was a white man who wanted to go to medical school, and he was a very strong candidate, but there were a limited number of seats for white students. See, the school held 16 of the 100 seats at the medical school for only black students, while there was no limit to the amount of seats black students could occupy. But for those 16 seats, race was an essential element that needed to be satisfied. So the Supreme Court rejected using race as an element, and it required schools to use a, quote, serious good faith effort in using other race-neutral means. But the court didn't require an exhausting of all race-neutral means. You just had to use race as a factor amongst other factors, like test scores, GPA, and extracurricular activities. Now, let's fast forward 48 years after Brown versus Board of Education and 25 years after Bakke. The Supreme Court ruled in another case called Grutter v. Bollinger. In 1997, Barbara Grutter, a white student from Michigan, applied for admission into the University of Michigan Law School. Now, Miss Grutter had a 3.8 GPA and was denied admission to the law school. Now, the law school used race as a factor in the admissions process and did not have a racial quota, but was using race to make a more diverse student body. Now, the Supreme Court's opinion, authored by Supreme Court Justice Sandra Day O'Connor, found that race could be used as a factor, and that the school was permitted to use race in determining admissions. The court also theorized that this fix of using race as a factor amongst other factors would be a temporary fix to right the wrongs of the past. This was also known as the Grutter Rule. The majority wrote, "This court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Now, what this did is it had the effect of limiting race in college admissions because it was just, again, another factor to consider amongst other factors. So let's recap affirmative action. First, race was used as an element to include black students to right the wrongs of the past, and this occurred for the first 21 years. Then the court scaled back that rule, allowing race to now be used as a factor and for race to be weighed against other factors like extracurricular activities. Now, this went on for the next 46 years, from 1977 to about 2023. So now the Supreme Court has ruled that race cannot be used in the college admissions process in the landmark case, Students for Fair Admissions versus the University of North Carolina and Harvard. In this landmark decision, the Supreme Court ended the Grutter Rule that allowed race to be used as a factor in admissions. So let's just step back. Remember, for about 70 years after Brown versus Board of Education, we've had some form of affirmative action. Race went from being an essential element to admissions, if you're black, you get in, to it being a factor in admissions, to now it being illegal in the admissions process. So the question most people are asking is, what would be the effect of ending race-based admissions policies? Now, you may be surprised that some states have already banned the practice of race-based admission policy. For instance, we have extremely liberal California, who banned it back in the 90s, and you have conservative Texas, who's also banned the process. But first, let's start in Texas. See, in Texas, they have a policy called the top 10%. So if you go to a public high school in the state of Texas and you're in the top 10% of your graduating class, you automatically receive admission to any of the public universities in the state of Texas university system. Schools like Texas A&M or the University of Texas. Meaning, if you go to a really great high school in a rich community or a really bad high school in a poor community, you get in. Now, statistics show that high schools in predominantly black neighborhoods are generally lower performing, but based on this rule, they would have an equal opportunity to go to any college in Texas. This policy had the effect of eliminating race-based admissions, but acknowledging the difference in socioeconomic standing within the state. California is another state that also banned race-based admissions back in 1998, so no one is calling California a racist state. Now, this did lead to less minorities going to the most elite schools in the states, but it also did lead to a rise in attendance in the other universities within the state. So essentially, less black students going to, let's say, Harvard, but more black students going to the University of Texas. So now that brings us back to today. The court led by Chief Justice John Roberts has said enough is enough. Essentially, the majority claims that this remedial measure of considering race in admissions needs to end. It's been 70 years. Now, don't get it twisted. Racism is not defeated. But this type of racial discrimination, the court feels it's long in our past. Now, the other side claims that this practice needs to go on because minorities are still suffering. But even some staunch liberals have supported the court's ruling.
Before I do, Jake, what do you think about this ruling?
Okay, brace for impact. I agree with it. So I've actually said that I'm against affirmative action probably dozens of times on this show, but nonetheless, people are surprised whenever you go outside of orthodoxy. So I think affirmative action was definitely correct in the beginning. I'll give you a quick example of why. So for example, if you're, just pick a random profession, you're a longshoreman, you got a good job, it pays decent wages back then, right? It started in the 1960s. And you want to pass your job on to your kids. That makes sense. I get it. I get your motivation behind it. But at the time, only white people had those jobs. So they would constantly pass their jobs on to other white people, their kids, which again, as a parent, I get it, but we had to allow minorities to break into that system. And we had to do that at every level for jobs, universities, etc., because folks did not have an opportunity, okay? But after a while, it becomes stigmatizing. So I'll give you another anecdote. When I was in law school, I remember back then I was a Republican, and I remember being with a couple other Republican students, and I said about one of our classmates and someone who I was friends with, but they didn't know that. They said, "Oh yeah, I wonder how he got in here." And I thought, and I said, by being a great student. But for them, every minority, it doesn't matter if they went to Harvard, Princeton, where, Yale, Stanford, nothing mattered. It was disqualified because of their race. Oh, they didn't earn it. And I think that has had a massively corrosive effect in this country against minorities. So I think it has now become counterproductive. I agree with the Supreme Court's decision. I have more on.
So what do you think? Do you agree with Cenk? Was this the right decision or was this the wrong decision? The comment section is where you tell me what you think. My name is Nate the Lawyer, and I'll see you next time. Peace.